Welcome to Who Wrote That Up For You, a daily podcast that shines a light on the American justice system and its role in empowering the powerful to take from you. The justice system is the only branch of your government where an individual, rather than the collective, can make the system act for you. It puts power in the individual's hands, but it's broken and being used against you at a time when you need it most.
And welcome to Who Wrote That Up For You. Normally, I would say we are live on the show, but today, Deborah and I are actually flying back from San Francisco to Durham at the time of this broadcast. And so we are recording this ahead of time. But today would be Friday, October 21st, 2022, at the time of this broadcast. I am Sonia Ebron, co-founder at Courtroom 5.
And I am Deborah Sloan, the other co-founder at Courtroom 5.
Got a wonderful show lined up for you today. In a few moments, we'll speak with Nick Rishwain. He is the creator of experts.com for expert witnesses. And we'll love to hear that story and talk about how to retain an expert witness. Before we get there, though, Deborah, what is on your mind today?
I want to talk about court behavior and court protocol and the difference between what behavior is seen as acceptable and what behavior is seen as kind of almost disruptive, but it should be acceptable. For example, you come into a courtroom, the judge comes in, people stand up. It's okay to do that. The judge, ask, everybody, okay, who's present? It's okay to do that. But then there are times when you know that there's something that you should not be saying in court, and a judge wants you to say it anyway, or something you need to say and the judge won't let you say it. We've had personally in court situations where the judge really doesn't want to hear from us. They just pretty much want to rule based on what sometimes typically a lawyer said. And the judge might just run, okay, so the lawyer said that, all right, so, I'm going to just go. And as a pro se litigant, you have to be a little bit more assertive. And so there are times when you have to say, would the judge, something like, would the judge like to hear argument? Because you sitting here with your argument and the judge is like, well, he just made a very good argument and I pretty much don't know why I have to listen to you. So some people call that protocol and letting the judge run the courtroom. But if you have something you need to say, that's not protocol. That's part of taking care of yourself and owning your case. So kind of be aware of, and this is what we try to do in court, be aware of what is protocol and what is taking care of yourself in court.
And this is so interesting because, as you know, I've used those exact same words in court. A judge is rambling off and about to make a decision without having heard from me. And, I just have to interrupt. Would you like to hear some argument on that? Your Honor, it's a shame. And we have run across a wide variety of judges, some who are absolutely focused on providing a neutral playing field, or even in rare instances, bending over backwards to make sure that we as pro se litigants are heard. And then there are others who just want to get us off the docket as quickly as possible, right? And make whatever decisions are necessary to make that happen without hearing us. And so it is absolutely necessary, as you say, to be proactive, to anticipate certain things happening in court, and to be assertive to make sure that you get your positions heard. Absolutely. Well, thank you, Deborah, for raising that issue. It's something that I think we'll be harping on many times over the course of this show. Who Wrote That Up for You is sponsored by Courtroom 5. At Courtroom 5, we believe the courts belong to the people, in particular to the people who use them. And we, the people, are coming to claim our courts. So if you are in court without a lawyer, or if you need to sue someone and can't find a lawyer to represent you, get yourself over to courtroom5.com. Try a limited version of our services for free, and we hope to provide some relief for you there. At this time, it's my great pleasure to welcome onto the show Nick Rishwain. And Nick, let me say ahead of time, I've been on your show. Welcome to our show. I want to make sure that I pronounced your name correctly, and if not,
You did. She had Sonia had to correct me on my show when I pronounced her last name. So I'm very impressed.
It's so easy. You know, we know each other from a range of events and whatnot, and I know you as Nick. You know me as Sonia, and that's the end of the story.
That's it.
That's great.
Thank you for having me on. I really appreciate you. I appreciate what Courtroom 5 does to help close that justice gap. So happy to be here. I should note that I am not the creator of experts.com. I'm the creator of Legal Tech Live, my podcast. I am vice president of business development and client relations at experts.com.
Fantastic. Thank you for that correction.
My pleasure.
Glad to have you. Regardless of that, let me ask then, let's dial it way back and help us understand what is an expert or an expert witness. Why do they exist?
They exist to basically help the jury, sometimes the judge, to understand a complex technical issue that is primarily, outside the knowledge of a layperson. And that's why they exist. They come in to provide some sort of technical analysis or scientific analysis that a layperson or lay jury may not understand without further elaboration from somebody who has that experience. Such as in the medical field, you need to have an orthopedic surgeon or somebody like that come in and testify about something that went wrong in an orthopedic surgery.
Excellent. And so typically at trial, you might bring a fact witness, someone who could say what they saw or heard or something like that, someone who has facts to testify to in that way. But these experts obviously would not have been on the scene, for instance, of an accident or a surgery that gone wrong or that sort of thing. And so they're sort of reviewing reports or other facts from some of the other witnesses. Is that how it goes?
Yeah. So there's generally admissible evidence, medical records or police reports, those types of things that are admitted into evidence. The expert is asked to review that evidence. They didn't actually witness this thing happen. They whatever the incident might be, they didn't witness it, so they are basically reviewing documentary evidence to make to provide their expert opinion as to was this within what is called the standard of care, or was this the appropriate use of force? Has been a big one, recently with police brutality matters. So you have to have somebody who's got some experience, training, knowledge in those areas, whether it be medical or law enforcement, engineering, and they review all this demonstrative evidence, anything that would give them an idea as to how the incident may or may not have been within the standard of care in a civil case is often what they're looking at. In a criminal matter, it's often some form of, was it following policies and procedures, or is there a DNA issue in the matter? So that's generally what they're reviewing. Sometimes there's video. Depending in a criminal case, we often see a lot of video now. In a civil case, maybe there is no video to go back to, so it'd be something like medical records that they would review.
Absolutely. That's great explanation. And so if if I were called, for instance, into a surgery gone wrong type of case, right? I know nothing
Hmm.
about surgery. Maybe sometime on good days I know something about machinery, right? That sort of thing, electric
Sure.
power lines, right? But if I got called as a witness by someone in a gross negligence case around
Hmm.
surgery, I wouldn't be qualified to speak to uh, any evidence at all in the case, right? How are expert witnesses qualified when they might be called to testify?
Yeah, and I think that's probably where you distinguish between the fact and the expert witness. You may be called to testify as a fact witness if you were actually standing in that room during the gross negligence, right? And you heard something, you overheard something that the doctors were saying to each other, or you viewed them do something that even as a layperson you thought was weird, right? So if you were viewing it, then you'd be called in. The expert is generally qualified by a court. It's different by state and by federal courts, of course, as Courtroom 5 is well aware of the many jurisdictions within our country. But essentially, we'll go with the federal court standard, which is called the Daubert standard. Or even Daubert. Nobody actually. I think it's actually Daubert, but nobody really says it the same. But that, and then that's been codified in Federal Rule of Evidence 702, and that's a variety of elements, that I'm not going to bore your listeners with, but it's like, was this scientific methodology? Was it generally accepted by this? Um, and generally accepted may be one of the states rather than the federal. So don't quote me on that one. But was a scientific methodology followed in reviewing the evidence, based on your opinion, based on your experience? You are qualified by the judge. They'll usually have a Daubert motion. So plaintiff would propose their expert witness. The judge acts as the gatekeeper. So the judge has to have and the defense might say, we don't want this expert. We don't think they're qualified to testify. So there's a variety of motions and hearings on whether or not somebody is going to actually testify. State courts generally are a little bit more lenient there. Of course, they have, really impacted civil schedules or dockets, and so if it's the local San Joaquin or Alameda County court, they may say, they may have seen Nick Rishwain or Sonia Ebron be an expert before, right? So we know that Sonia's an expert. We know Deborah's an expert. So it might go a little faster there because you've been in front of Judge so and so several times. But if it's a really heated litigation, there's going to be a fight over whether or not we're accepting, whether they pass the Dauber motion, or if they pass a state criteria for testifying. And that's basically the court qualifies you to be an expert witness.
Fantastic, and this is a big deal in many cases, particularly big dollar. Where large awards are possible.
Mm-hmm.
Oftentimes, you can have all the fact witnesses in the world,
Mm-hmm.
but if you don't have an expert to sort of impute some meaning to those facts for the judge or jury, you could lose your case. And so,
Sure.
yeah, it's a big deal. That's
Not
fantastic.
only lose your case in the big dollar ones, but one that we should all keep in mind, not just in the civil, but in the criminal side. Uh, you it may be ineffective assistance of counsel if you did not if the defense attorney did not seek an expert witness to testify about something that was really important. And this all leads, almost adding layers or brick by brick, to now we've got a wrongful conviction and now we're trying to overturn it, and that's a serious thing to try and unring that bell. So it has, they can make or break a case, whether it's criminal or civil. Um, and and oftentimes there will be questions over that testimony or that purported evidence in appeals.
Fantastic. That's a truly important point, particularly in situations where you have a public defender's office with a very limited budget to hire
Sure.
expert witnesses. So we'll
Yeah.
pick up there in just a moment.
Okay.
We'll hear about Deborah's challenge for the day, and we'll bring you right back in just a moment.
Sounds good.
Oh my goodness, this expert witness issue. I know you, Deborah, have had tremendous experience with there. Yeah, as unlike most pro se litigants. So we definitely want to chat with Nick about some of that experience in a moment. But before we get there, who won our quiz yesterday?
Well, we are recording this before yesterday, so so we don't know yet. So I will report Thursday's winner on Monday. Okay.
That's fair enough. Fantastic. All
But
right then.
I
Since
can
this is
present today's quiz.
fantastic.
And the question for today is provide one standard of review in an appeal. What is one standard of review in an appeal? If you want to participate in this quiz, send your responses to quiz@courtroom5.com.
Oh, that should be fun. Looking forward to seeing the answers there. And so we will hopefully celebrate winners of both Thursday's quiz and Friday's quiz on Monday. So stay tuned for that. Fantastic. Let's bring Nick back at experts.com to talk more about the use of expert witnesses. So, Nick, where we left off, we were talking about the use of expert witnesses in criminal cases in particular. If you're a criminal defendant and the state has all the budget in the world to try to lock you up, that as a criminal defendant, most of us these days cannot afford to hire a criminal defense attorney. We certainly aren't able to hire some expert witnesses to counter. The state has a crime lab and can bring in experts in all different types of issues to testify. You've got to counter that evidence and that expert testimony some way as a criminal defendant. What do you see, in regards to criminal defense these days?
Yeah, it's a difficult issue. I've seen some things that I like, some attempts to remove the police forensics arm from being part of police departments and making them kind of independent agency, right? So that they're not feeling like they're unduly influenced to reviewing certain evidence and finding in a certain way. That I think could be good. I guess being independent provides a whole host of other issues. But the public defender one it's difficult, and even criminal defense for an indigent client it is difficult because generally what defense counsel has to do is they have to make a motion to the court requesting fees for an expert witness. And quite often those fees are not, expert witness fees can pile up really quick. They're usually pretty expensive because they are taking time out of their day job, their day-to-day thing, to come down to court and do this thing. And so they usually get paid a premium on that. Not to mention they also have usually years and years of experience. And so they're things that I don't like on the criminal defense side is, I see some of the numbers that defense counsel are given for an expert witness, and it really is for a very narrow set of review. And maybe you get a check for $2,500 to seek an expert witness, and that's it's going to be hard to find an expert witness to willing to work for $2,500. Maybe those numbers are up to 5,000 now. I don't think so. Not the way county budgets are. They're strained pretty. They're pretty tight. So that's probably one of my biggest concerns about that. We've certainly found experts for public defenders with full knowledge that they were still going to have to motion the court and see if they could get approval to hire the person. But that's a difficult thing, and this is not just criminal. This is civil as well. If you are small business person, as we all are here, and you're in litigation, some sort of business litigation, you have to provide an expert. We're talking tens of thousands of dollars generally, and that is, and if you're paying for an expert on top of paying for your counsel, it's this really expensive aspect of litigation.
It is indeed. Absolutely. Well, that brings us to experts.com.
Sure.
And tell us what experts.com is and does, with respect to expert witnesses.
Yeah. So we're a marketing platform for expert witnesses. We have essentially a two-sided marketplace, lawyers on one side and experts on another. The experts pay a subscription fee to market on our website, which we have the name experts.com. And so we have pretty good traffic with that and pretty good visibility. And so they pay to be found by attorneys. The other aspect of what we offer is we tried for many years in our small portion of the access to justice to encourage attorneys. Go to our site, search it for yourself, contact on your own, reduce the costs, because some of our not direct competitors, but some of our competitors are brokers. And so they add a percentage markup on every billable hour, 35 to 50%. So if you're getting a $400 an hour expert witness, it's now $600 or $700 an hour expert witness, and they're brokering and keeping that difference, which is we thought just ridiculous. So we tried to make it more of search on your own, do your own. Lawyers still will ask us to do the search for them. So to offer that service, we do that on a flat fee basis so that we're not adding a significant expense to litigation. So that's what we do, essentially. Lawyers looking for experts and experts who are looking for lawyers for work, and we combine the two, or we allow them to, we do have a large number. The flat fee based service is maybe 1% to 2% of our traffic. There are plenty of firms now who are much more comfortable searching on their own, and of course they're getting pinched by clients to keep costs low and to be more efficient. So usually in a bad market, it's really good for us as far as who's coming to experts.com and searching for experts and locating them or asking us to locate an expert for them.
Fantastic. That's really interesting. I assume that if I, as a pro se litigant, wanted to hire an expert witnesses, the first thing I'd find would be experts.com.
I hope so.
I hope so too.
I want you to have it bookmarked, Sonia. I mean, just go. I don't want you to have to go looking for it.
You bet. And as I mentioned during the break, Deborah has some specific experience finding expert witnesses for various claims, but most expert witnesses don't want to work directly with pro se litigants. And I suspect we find the same situation at experts.com. Can you speak a bit to the reluctance of experts to work with pro se litigants?
Yeah. It is a problem, one I think in part Courtroom 5 is trying to solve, right, by helping people who are pro se to be better prepared and be able to kind of focus their attention. But dealing experts want to be paid, and sometimes getting paid by a pro se litigant is very difficult. So they think that if they communicate directly with the lawyer and the lawyer signs the retainer, they can always go after the lawyer, who they expect will be easier to recover from, or they'll require a retainer in advance from either side. Well, $10,000 retainer from a pro se litigant is usually not an easy thing to accomplish. The other is really, we often find ourselves, I'm sure you've found yourselves in this situation when helping pro se litigants, is to identifying what the issues really are. And you get these long drawn out explanations that, and an expert doesn't have time to spend on the emotional stuff. And they want to know, okay, what are the medical records, or what's the accident report, or something like that, and get right to it. So rather than offer some sort of counseling that the attorney really probably should be doing, right? So there's a variety of issues that way. They want to get paid, and they want to know what issues they're really analyzing and what they're writing a report. And there's a concern, there's other concerns, such as, okay, when I complete this report, I don't know what else this person's doing with it. They're not, I can go and find a law license online, and I don't know if this person has anything that I can actually, I don't know what they're doing with my report. Are they going to start screaming from Twitter that I said this horrific thing, and so lacks of professionalism, or fears of lacks of professionalism, I think, are other aspects of that. So I think a lot goes into it, but I think the biggest one is, I'd like to get paid for my work. I think I can hold an attorney responsible if they if and the attorney can chase the client for these costs. So it gives them that buffer and kind of streamlines what they're supposed to be looking at in the case.
Got it. And so if a pro se litigant is able to pay up front, pay a retainer to an expert witness, they're going to have a better chance of finding one to testify in their case.
I would suppose I would suppose that's accurate. If you can pay up front, that's certainly that's the other thing that experts don't want to deal with, is the negotiation and haggling over fees. Yeah. Right. So if you tell them, look, I'm $500 an hour, and you come back going, hey, can you take $750 total? They don't want to waste their time with that.
Sure.
But yeah, I think you're going to have a better time if you say up front that I can send you the retainer. Will you look at this? Absolutely. I mean, a check in their hands, or money order in their hands, or a wire to their account, all right, well, maybe I am going to take a look at this, but they're generally just very hands-off-ish when it comes to pro se, which is, and I tweet about it from my company account on occasion, like, hey, we get a lot of pro se litigants, and I have to tell them, here's where you can go to search our site, search for the expert that you're looking for. But I'm warning you up front that they can be reluctant to. I don't want to get anybody's hopes up that, I'm going to find this person, they're going to say yes. There's been a long history here of experts being unwilling to work with pro se litigant.
Right.
But I will tell you the numbers, as I expect you and Deborah are probably also noticing, the numbers of pro se inquiries that we're getting is going up pretty significantly.
I'll bet. No doubt.
2 or 3 a week that I see, by email, and so, which is up probably from 1 a month to that's pretty significant uptick in, say, 5 or 7 years.
we'll prepare for the storm here.
Yep.
That's great. Well, and as you mentioned, it also helps that when a pro se litigant knows which facts are relevant to the matter at hand and are selecting the right sort of expert.
Yeah, a lot of times I'll get that. I need a medical expert for my case.
Right.
That's
Which
okay.
is 30 different categories of medical
Yeah,
experts.
yeah, is what type of specialty, right?
Right.
And so they really don't know what they're asking for. So they call somebody up who's a cardiothoracic surgeon when what they needed was a, foot and ankle orthopedist or something like that, right? And so,
Right.
so
Yep.
those getting those types of inquiries as an expert, it usually would move you away from pro se litigant.
Got it. Got it. Nick, this is also very helpful. I'm going to share on the screen for our viewers the website experts.com so they can come and just see the wide variety of experts that you all have available there. Are there other ways to find you online?
Yeah, I mean, Sonia knows I'm all over Twitter. You can get me at experts.com VP. But certainly experts.com and LinkedIn. I'm at Nick Rishwain on LinkedIn and Legal Tech Live. There's just so many ways.
There are indeed. Fantastic. We'll share those in the show notes. Nick, thank you so much for sharing your expertise and what you all are doing at experts.com. We'll have you back to chat more about this soon.
Sounds great. Thanks, Sonia. Thanks, Deborah.
You bet. That is fantastic information, I think, for folks to just consider when you are handling your own case. The facts alone may not be sufficient for you. You also want to have those facts interpreted by an expert, oftentimes for the jury or the judge, in order to win your case or defend yourself against claims or criminal charges.
And you also want to make sure that you know what you want from each expert. He's correct about that. You have to know what evidence that they need to review and what you need to prove.
Absolutely.
Using their testimony. Yeah.
Absolutely right. You want to be able to put your expert's testimony into a play that's already written, if you will. Make sure that you get your money's worth there. Well, fantastic. That's all we have for today. Thanks, everyone, for tuning in, and we will see you on Monday.
Are you feeling beleaguered, angry, or afraid, as if things are spinning out of control and you're powerless to stop them? It's easy to just let things slide and hope they don't get worse. But they often do get worse. The thing is, you're not powerless. Our courts belong to us, and their purpose is to give power to the powerless. Don't let your grievances pile up without redressing them. You can handle this in court. Or, if someone takes you to court, you can take them to school.